Because, I mean, there's another portion here, I mean, part of the portions which actually earlier on, in the 2010 Electoral Act is amended, states that 14 days before the election, that's when the tribunal should be set up, but it's been increased to 30
days.
It's 30 days now.
So,
30 days.
So practically, you are a victim of delay in an election petition.
Yes.
What's your experience like, and what do you think these...
No, but you see, the truth about it is, I can't help but agree with Mr. Shitu here in terms of the fact that the burden of proof, if shifted to INEC, will help to actually sanitize our electoral procedures. Yes, I've been a victim, in the sense that, I'll give you an example. I had electoral materials and I was in the dock for about 1 hour. And while I was being cross-examined, I provided all the evidence, and the evidences I got were mostly from the internet. And at the end of the day, I was so happy because it has showed me all where the elections were rigged, and I was so happy. I held it like a Bible. But I wasn't the maker of the document. And that was where my opponent's lawyer came to prove the fact that Ken wasn't the maker of the document, so how can you bring documents that you're not the maker of? And it was actually admitted as an exhibit. Do you understand what I'm trying to say, Shimu? And because I wasn't the maker of the document, it came to nothing. Everything that was stated there came to nothing. But if what Shitu is saying is applied, in the sense that INEC comes to say, I conducted this election, and I'm going to prove, that body will not have rested on me. I wouldn't have been the one sitting down in the dock to say, this is how I'm going to.
So it's emphasizing the fact that INEC should have some form of this job.
They should have some of this job. But don't forget, we are an evolving democracy. I have considered to that. But as an evolving democracy, we must also accept that INEC has its limitations. And so, how can INEC, do they have the resources? Just like what Shitu has said, do they have the resources to employ lawyers in every election case? My case was a House of Rep case. You can imagine how many House of Rep cases that you have all across the country. Talk less of House of Assembly, talk less of chairmanship elections, talk less of presidential governorship elections. How can INEC provide lawyers who will come here and now come and defend every elections that are conducted? It's not possible.
But I guess...
so those are the limitations that INEC has, and which makes it impossible for the Senate to say, let us push this burden of proof to INEC.
All right.
Even though we all know that if you push the burden of proof to INEC, it becomes better for those of us who are politicians and are likely to go into election contests.
Status quo remains now.
That is the truth. Status quo remains.
One particular area that is also worrisome. Yes. The present trend, whereby election petition tribunals are limited to 180 days.
No, but they have shifted conducting it from 14 days to 30 days.
No, what I'm saying is that if you file an election petition,
yes.
The duration of time
to conclude it, 180 days. If you don't conclude within that 180 days, the court will say they don't have jurisdiction.
The tribunal.
The tribunal will say
Shitu, I'll disagree with you here.
No, let me just explain. I believe that the Senate ought to have extended that 180 days. We know that the previous practice, where you are in court for 3-4 years, is definitely unacceptable for determining election. But when you now say 180 days, for our courts to determine election petitions within 180 days, and with the frustrations that you may likely encounter from other agencies like INEC, a lot of people have been deprived of their rights because of these 180 days. And I think the Senate ought to have considered that and extend.
No, but Shitu, if I might come in here, 180 days is enough for you to prove your case. If you actually have your case. I mean, we all have our agents. For example, as a politician, when you're going into an election, you have your agents in each polling unit. Or the same way they relay the results, those INEC officials, your agents are relaying your results to you. So you should be able to put your case together between 7 days and 10 days.
So what if
when you're giving 180 days, it's enough time for you to be able to prove your case. Because I'll give you an example. My principal, for example, his election was nullified on the 10th of November, 2010. He was already more than 3 years in office. That's enough distraction. Okay, today we're having elections in Ekiti in 2014. We had elections in Anambra earlier on in the year. We had elections in Edo. So it is all distorted. So if this amendment was not done, if this amendment was done earlier on, Shitu, you must agree with me that all these staggered elections we're having in these different states would not be the case. Because in 180 days, it's either you prove your case or you go to the appeal court and you prove your case and your case is determined. Right. If we go beyond 180 days, that will distract our the people who are in office.
Let's quickly look
I
at.
don't think
Let's
that's right.
look at some other areas. I mean, that is controversial in it because I mean, in the Nigerian legal practice itself, the issue of the extension of cases and all of that has been. I know you by now. Most of you are, and I know some lawyers are actually experts in dragging
Delaying
issues,
cases, yes.
Barrister Situ, this is actually very interesting. The Senate also rejected the proposed amendment to Section 87 of the Electoral Act, seeking to empower INEC to disqualify any candidate who fails to comply with provisions of the Constitution as well as the Electoral Act.
I think that's a salutary provision. If you allow INEC to disqualify candidates, wittingly or unwittingly, you will be defeating the very essence of democracy. You understand me? The democracy is anchored on the freedom of choice. People should have the right to go to heaven the way they want. You understand me? You understand what I'm saying? So if you shadow INEC, the argument of INEC is that it is not just a management body. That INEC is also a regulatory body, and as such, INEC should have such powers as are vested in CBN, for instance, to revoke bank licenses and determine nominees of directors on the board, and then NAFDAC to seal off,
companies that flout their orders.
That flout the orders. Being a management and regulatory body, you should have also powers to disqualify candidates. But I have a different perspective. My own perspective is that that will be vesting in INEC too much powers to tamper with the freedom of the people to elect or choose people they want. Political parties to choose whoever they want to contest elections. So I think what the Senate has done personally is accord more with the rule of law, in that if you want candidates disqualified, you go to court. When you then get a judicial pronouncement disqualifying a particular candidate on the strength of violation of Section 66, 67, 103, and some other provisions of the Constitution, then on the strength of that, INEC can then act to disqualify the candidate. I don't think it will serve our democratic process well to vest the power to disqualify in INEC. I think it should rest with the judiciary as an impartial arbiter.
Umpire.
Yes.
Oh,
yes.
Interesting.
I think
what this amendment has done, I think, is salutary.
What I think the Senate has done is exactly they have come with the Constitution of the Federal Republic of Nigeria. If you actually give INEC the power to disqualify a candidate, for example, if you remember when they said Ibori was not qualified in 2003 to conduct an election, for almost like 2 weeks to the election, Ibori's name was not released by INEC. And then the courts had not disqualified Ibori from contesting the election. But because he had a pending case in court, INEC was of the opinion that if he lost that case, he would not have been a qualified candidate. And I don't think he's right until the court determines. You see, we're in public office, for example. I can want to go for an election. Do you understand? And all kinds of allegations can be made against me.
That can disqualify.
That it can disqualify me.
So you're happy as a politician?
Oh, I'm very happy. Because I would not want INEC to just come and disqualify when the court cannot disqualify me. Do you understand what I'm trying to say?
Interesting.
And mischief makers can cap in on it and come and say, oh, this person does not have this, person does not have this. But until the court rules otherwise, because they would always hold on to their case and they hold on to it tenaciously. I know when a lie is told, it tends to sound like it's truth.
Anybody who does not like your face should go to court.
Should go to court. That's exactly what
I think that's
and the court will look at the processes. Facts are sacred. You can't change facts. Do you understand? If you say this is it, this is it. If the court looks at it, the court can say, oh, Ken does not have this required qualifications, and so he cannot contest an election. But human beings can come and say, you don't have this. Just because you're in public office, they can allege all sorts. And I mean, for me, sitting down in public office, I've seen enough of that.
All right. Interesting. Well, my guests are still here. But another perspective to all of what we've been discussing, again, is the fact that we talk about debates in our election. Well, part of this is the fact that this law does not mandate the president to appear before a debate. Well, that's another interesting angle to the discussion.